Hello and welcome to Study with Sri. Here I am covering Indian Polity by M.Laxmikant chapter wise. So today's topic is Basic Structure of the Constitution. Basic structure of the Constitution. Emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of Supreme Court within a year of the Constitution coming into force. Okay, so question whether fundamental right can be amended by the Parliament. Parliament fundamental right को amend कर सकते हैं कि नहीं under Article 368 came for the consideration of Supreme Court within a year of the Constitution coming into force. In Shankari Prasad case, that is 1951, the constitutional validity of First Amendment Act, the 1951, which curtailed the right to property, was challenged. Okay, so Shankari Prasad case में constitutional validity of the First Amendment Act कब हुआ था 1951 में, जो कार्टेल किया था right to property was challenged. Supreme Court ruled that the power of Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. Okay, and Supreme Court ruled that power of amendment under Article 368 also includes power to amend the fundamental right also. So the word law in Article 13 includes only ordinary laws and not constitutional amendment acts, that is constituent laws. Therefore, Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment act, and such a law will not be void under Article 13. Okay, so Article 13 में क्या बोला गया था ना, कोई भी लॉ अगर है जो inconsistent है और in derogation है any of the fundamental rights से, that law shall be void. But here in Shankari Prasad case, the word law in Article 13 includes only ordinary law, ये बोला गया था, ठीक है, and not the constitutional amendment act. Okay, so Parliament के पास power होगा कि Parliament can take away or abridge any of the fundamental rights by enacting constitutional amendment act. Such a law will not be void under Article 13. But in Golaknath case 1967, Golaknath versus State of Punjab. Okay, Golaknath case में क्या हुआ, Supreme Court reversed its earlier decision, and in that case the constitutional validity of the 17th Amendment Act, which inserted certain state acts in 9th schedule, was challenged. Okay, 9th schedule क्या था ना, 9th schedule में अगर कोई भी law है उसका judicial review नहीं हो सकता है. So गोलकनाथ केस में सुप्रीम कोर्ट रिवर्स किया उसका अर्लियर स्टैंड को. इन दैट केस कॉन्स्टिट्यूशनल वैलिडिटी ऑफ 17th अमेंडमेंट एक्ट जो था ना, which inserted certain states act in the 9th schedule, was challenged. The Supreme Court ruled that fundamental rights are given a transcendental and immutable position. Okay, that is fundamental rights are sacrosanct in nature. एक मतलब होली है बहुत ज़्यादा, ट्रांसेंडेंटल इम्यूटेबल पोजीशन क्रिएट करता है, एंड हेंस पार्लियामेंट कैन नॉट टेक अवे और एब्रीज एनी ऑफ दीज फंडामेंटल राइट्स. सो अ कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट इज ऑल्सो लॉ विद इन द मीनिंग ऑफ आर्टिकल 13 एंड हेंस वुड बी void फॉर वायलेटिंग एनी ऑफ द फंडामेंटल राइट्स. ओके, एंड गोलकनाथ केस में क्या बोला, आर्टिकल 13 के अंडर कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट भी आता है. ओके, हेंस would be void violating any of fundamental rights. The Parliament reacted Supreme Court's judgment in Golaknath case. So Supreme Court judgment दिया, नहीं कर सकते fundamental rights को amend. उसके बाद Parliament क्या किया, Parliament enact किया 24th Amendment Act 1971. Okay, this act amended Article 13 and 368. मतलब Article 13 को ही amend कर दिया गया और 360 को भी, 368 को भी, जो अमेंडमेंट है, एंड आर्टिकल 13, ठीक है. इट डिक्लेयर दैट पार्लियामेंट हैज द पावर टू एब्रिज और टेक अवे एनी फंडामेंटल राइट्स अंडर आर्टिकल 368, एंड सच एन एक्ट विल नॉट बी ए लॉ अंडर द मीनिंग ऑफ आर्टिकल 13. ओके, सो 24th अमेंडमेंट एक्ट में आर्टिकल 13 एंड 368 को अमेंड कर दिया गया. एंड बोला गया कि पार्लियामेंट हैज द पावर to abridge or take away any fundamental rights under Article 368, that is under amendment, and such an act will not be a law under the meaning of Article 13. Okay. However, in Keshavananda Bharti case, that is Keshavananda Bharti versus State of Kerala, 1973, Supreme Court overruled its judgment in Golaknath case 1967. It upheld the validity of 24th Amendment Act 1971 and stated that Parliament is empowered to abridge or take away any of the fundamental right. Okay, 24th Amendment Act में क्या बोला गया कि जो आर्टिकल 13 और 368 को अमेंड कर दिया गया था एंड बोला गया था कि पार्लियामेंट इज एम्पावर्ड टू एब्रिज और टेक अवे एनी ऑफ द फंडामेंटल राइट. बट केशवानंद भारती केस क्या किया ना, एट द सेम टाइम इट लेड डाउन अ न्यू डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर और बेसिक फीचर्स ऑफ द कॉन्स्टिट्यूशन. ओके, सो इट रूल दैट द कॉन्स्टिट्यूएंट पावर ऑफ पार्लियामेंट under 368 does not enable it to alter the basic structure of the constitution. Okay, amendment करके basic structure का change नहीं हो सकता है. This means that parliament cannot abridge or take away a fundamental right that forms a part of basic structure of the constitution. The doctrine of basic structure of constitution was reaffirmed and applied by Supreme Court in Indira Nehru Gandhi case 1975, that is Indira Nehru Gandhi versus Raj Narayan 1975. Okay, ये जो डॉक्ट्रिन था बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन was reaffirmed, मतलब फिर से reaffirm कर दिया गया था and applied by Supreme Court in Indira Nehru Gandhi case 1975. In this case, Supreme Court invalidated a provision of the 39th Amendment Act 1975. So in this case Supreme Court invalidate किया एक provision of 39th Amendment Act of 1975 which kept the election disputes involving the Prime Minister and Speaker of Lok Sabha outside the jurisdiction of all courts. Okay, so ये जो 39th Amendment Act था 1975 का, that kept the election dispute involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of court. The court said that this provision was beyond the amending power of parliament as it affected the basic structure of the constitution, and judicial review is the basic features of the constitution, basic structure of the constitution. Again the parliament reacted to this judicially involved doctrine of basic structure by enacting 42nd Amendment Act of 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of parliament and no amendment can be questioned in any court on any ground including that of the contravention of the fundamental rights. Okay, again parliament react किया था to this judicially innovated doctrine basic structure by enacting 42nd Amendment Act of 1976. अगेन चेंज करने का कोशिश हुआ. दिस एक्ट अमेंड किया था आर्टिकल 368 को एंड डिक्लेयर दैट देयर इज नो लिमिटेशन, कोई भी लिमिटेशन नहीं है ऑन द कॉन्स्टिट्यूएंट पावर ऑफ पार्लियामेंट एंड नो अमेंडमेंट कैन बी क्वेश्चन इन एनी कोर्ट ऑन एनी ग्राउंड इंक्लूडिंग दैट ऑफ कंट्रावेंशन ऑफ द फंडामेंटल राइट्स. मतलब कोई भी कोर्ट में चैलेंज नहीं किया जा सकता है. हाउएवर सुप्रीम कोर्ट इन मिनरेगा मिल केस, दैट इज Minerva Mills versus Union of India 1980 case, invalidate this provision as it excluded judicial review, which is a basic features of the constitution. Applying the doctrine of basic structure with respect to Article 368, the court held that since the constitution had conferred a limited amending power on the parliament, the parliament cannot under exercise of that limited power enlarge that very power into an absolute power. मतलब कॉन्स्टिट्यूशन कन्फर किया एक लिमिटिंग अमेंडिंग पावर पार्लियामेंट को एंड द पार्लियामेंट कैन नॉट अंडर द एक्सरसाइज ऑफ दैट लिमिटेड पावर. ये जो लिमिटेड पावर का एक्सरसाइज है, पार्लियामेंट कैन नॉट इनलार्ज दैट वेरी पावर, मतलब उसको इनलार्ज नहीं कर सकता है इनटू एब्सोल्यूट पावर, जिसको चेंज नहीं कर सकते हैं, जिस पावर को कोई भी उसका चेंज नहीं कर सकते, ऐसा नहीं कर सकते पार्लियामेंट. इंडीड अ लिमिटिंग अमेंडिंग पावर is one of the basic features of the constitution, and therefore the limitation on that power cannot be destroyed. Okay, so indeed a limited amending power is one of the basic features of the constitution. Okay, limited amending power जो है वो basic feature है constitution का, and therefore the limitation on the power cannot be destroyed. In other words, parliament cannot under article 368 expand its amending power so as to acquire for itself the right to repeal or abrogate the constitution or to destroy its basic features. The done of limited power cannot by the exercise of that power convert the limited power into an unlimited one. So, the donee of limited power cannot by the exercise of that power convert limited power into unlimited one. मतलब parliament limited power को unlimited one नहीं कर सकते हैं, ठीक है? And in other words, parliament cannot under article 368 expand its amending power so as to acquire for itself the right to repeal or abrogate constitution or to destroy its basic features. Basic features को parliament destroy नहीं कर सकते हैं. Again, Vaman Rao case 1981, that is Vaman Rao versus Union of India 1981, Supreme Court adhered to the doctrine of basic structure and further clarified that it would apply to constitutional amendments enacted after April 24, 1973. That is the date of the judgment of in the Keshavananda Bharti case. So, Vaman Rao case में क्या हुआ ना, सुप्रीम कोर्ट adhere किया to the doctrine of basic structure and further clarify किए कि that it would apply to constitutional amendment. अब जो constitutional amendment होगा after 24 अप्रैल 1973 में ये जो basic features है ये apply होगा. Okay, the date of judgment in Keshavananda Bharti case. Elements of the basic structure. The present position is that Parliament under Article 368 can amend any part of the Constitution including the fundamental rights but without affecting the basic structure of the Constitution. So, present position जो है Parliament का under Article 368 that Parliament can amend any part of the Constitution including fundamental rights but without affecting, but Parliament cannot affect the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. So, basic structure जो था वो तो पहले से नहीं था ना Constitution में mention. तो by from various judgments, Supreme Court basic structure को define करते हैं, ठीक है? The following have emerged basic features of the Constitution or elements of the basic structure of the Constitution. So, basic structure अभी कौन सा है? First is supremacy of the Constitution. Constitution का supremacy. Okay. Sovereign, democratic, republican nature of Indian polity. Okay. Sovereign, democratic, republican nature of Indian polity. Secular character of the Constitution is the basic feature of the Constitution. Okay. Separation of powers between legislature, the executive and the judiciary. Okay. Separation of power between legislature, executive and the judiciary. Federal character of the Constitution is a basic features of the Constitution. Unity and integrity of the nation. Welfare state, that is socio-economic justice. Judicial review, very important, basic features of the Constitution. Freedom and dignity of the individual. Okay. Parliamentary system, rule of law, harmony and balance between fundamental rights and directive principles, principle of equality, free and fair election, independence of judiciary, limited power of Parliament to amend the Constitution, elective access to justice, principle or essence underlying the fundamental rights. Powers of Supreme Court under Article 32, 136, 141 and 142. Okay. Powers of High Court under Article 226 and 227. So, Supreme Court ka power Article 32 constitutional remedies, right? 136, 141, 142 and power of High Court under Article 226 and 227. These are the basic features of the constitution. So ये जो basic feature है ये याद रखना बहुत ज़्यादा important है क्योंकि prelims में इसे question आता है. Which are the basic features of the constitution? So I am discussing again. Supremacy of the constitution. First, we know that our constitution is supreme. This is basic feature. Second, sovereign democratic republican nature of Indian polity. Preamble में जो mentioned है, sovereign democratic republican nature. Third, secular character of the constitution. Fourth, separation of power between the legislative, executive and judiciary. Fifth, federal character of the constitution. Then, unity and integrity of the nation. Welfare state, DPSP, right? Directive principle of state policy. Socio-economic justice, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between the fundamental rights and directive principle, principle of equality, free and fair election, independence of judiciary, limited power of the parliament to amend the constitution, okay, effective access to justice, principles or essence underlying the fundamental rights, power of Supreme Court under Article 32, 136, 141 and power of High Court under Article 226, 227. Evaluation of the basic structure of constitution. So here you can see name of case and year, and in right hand side elements of basic structure as declared by Supreme Court. So कौन सा basic structure कौन सा case में add हुआ. First case is very popular judgment, that is केशवानंद भारती case जो basic structure doctrine को add किया, popularly known as fundamental rights case. Okay, so कौन सा element add हुआ? Supremacy of the constitution. Separation of power between legislature, executive and judiciary. Third is republic and democratic form of the government. Fourth, secular character of the constitution. Fifth, federal character of the constitution. Then sovereignty and unity of India. Then freedom and dignity of the individual. Mandate to build a welfare state, DPSP and parliamentary system. Okay, so कौन सा ऐड हुआ देखते हैं और एक बार. First is supremacy of the constitution. Second is separation of power between legislature, executive and judiciary. Third is republic and democratic form of the government. Then fourth is secular character of the constitution. Fifth is federal character of the constitution. Sixth, sovereignty, unity of India. Seventh, freedom of dignity and individual. Eighth, mandate to build welfare state. Ninth, parliamentary system. Clear? Now next case is Indira Nehru Gandhi case. Okay, that is Indira Nehru Gandhi versus Raj Ranayan 1975, popularly known as election case. कौन सा case? Election case. So कौन सा basic structure add हुआ? India as a sovereign democratic republic country. Okay, India as a sovereign democratic republic. Then equality of status and opportunity of an individual. Equality of status and opportunity of an individual. Then secularism and freedom of conscience and religion. Then government of laws and not of man. Very very important. Government of laws and not of men. That is rule of law. Then judicial review. Then free and fair election, which is implied in democracy. Okay, free and fair election which is implied in democracy. So Indira Nehru Gandhi case में first is India as a sovereign democratic republic. Second, equality of status and opportunity of an individual. Third, secularism and freedom of conscience and religion. Then fourth, government of laws and not of men, rule of law. Then fifth, judicial review. Sixth, free and fair election which is implied in democracy. Then is Minerva Mill case. Minerva Mill case 1980 में कौन सा ऐड हुआ? Limited power of the parliament to amend the constitution. Okay, parliament के पास limited power है to amend the constitution. Then judicial review. Harmony and balance between fundamental rights and DPSP. ये बहुत important है. Harmony and balance between fundamental rights and DPSP added by Minerva Mill case. Okay. Now Central Coalfield Limited case. Central Coalfield Limited case versus Jaiswal Coal Company. Okay. So 1980 में हुआ था. Effective access to justice. Then Veem Shinji case. Veem Shinji versus Union of India 1981. It added welfare state, socio-economic justice. So Central Coalfield Limited case में effective access to justice 1980. Veem शिंजी केस में वेलफेयर स्टेट, दैट इज सोशियो इकोनॉमिक जस्टिस. एसपी संपत कुमार केस 1987, रूल ऑफ लॉ एंड जुडिशियल रिव्यू. Okay, rule of law and judicial review. Clear? Now P. Sambhamurthy case 1987, that is P. Sambhamurthy versus State of Andhra Pradesh 1987. This case में कौन सा ऐड हुआ? रूल ऑफ लॉ एंड जुडिशियल रिव्यू. ठीक है. एसपी संपन्नाथ कुमार केस में भी रूल ऑफ लॉ जुडिशियल रिव्यू. बस भीमजी शिंदा केस में वेलफेयर ऑफ स्टेट, वेलफेयर स्टेट. ठीक है. दिल्ली जुडिशियल सर्विस एसोसिएशन केस 1991 में पावर ऑफ सुप्रीम कोर्ट अंडर आर्टिकल 32, 136, 141, 142. देन इंदिरा शाहनाई केस, अगेन इंपॉर्टेंट केस, इंदिरा शाहनाई 1992. ओके, इंदिरा शाहनाई वर्सेस यूनियन ऑफ इंडिया 1992, पॉपुलरली नोन एज मंडल केस, रूल ऑफ लॉ. ओके. देन कुमार पद्मा प्रसाद केस 1992, इंडिपेंडेंस ऑफ जुडिशियरी. देन वेरी वेरी इंपॉर्टेंट केस, कियोटो होलोहन केस, Kyoto Holohan case 1993, popularly known as defection case. Free and fair election, sovereign democratic republican structure. Okay, free and fair election, sovereign democratic republican structure. Then Raghunath Rao case 1993, Raghunath Rao case में क्या हुआ था? Principle of equality, unity, integrity of India. Then एसआर बोम्माई case, federalism, secularism, democracy. एसआर बोम्माई केस में फेडरलिज्म, सेक्युलरिज्म, डेमोक्रेसी. ओके, फेडरलिज्म, सेक्युलरिज्म, डेमोक्रेसी, यूनिटी एंड इंटीग्रिटी ऑफ द नेशन, सोशल जस्टिस एंड जुडिशियल रिव्यू. ठीक है. सो एसआर बोम्माई केस में फेडरलिज्म, सेक्युलरिज्म, डेमोक्रेसी, यूनिटी एंड इंटीग्रिटी ऑफ नेशन, सोशल जस्टिस एंड जुडिशियल रिव्यू. देन एल चंद्र कुमार केस 1997, पावर ऑफ हाई कोर्ट्स अंडर आर्टिकल 226, 227. कौन सा केस में? एल चंद्र कुमार केस, इंदिरा साहनी केस 2. सो इंदिरा साहनी 2 केस 2000 में जो हुआ था, प्रिंसिपल ऑफ इक्वलिटी. देन ऑल इंडिया जजेस एसोसिएशन केस 2002, इंडिपेंडेंट जुडिशियल सिस्टम. देन कुलदीप नायर केस, डेमोक्रेसी एंड फ्री एंड फेयर इलेक्शन. देन एम नागराज केस 2006, प्रिंसिपल ऑफ इक्वलिटी. देन IR कोएल्हो केस 2007, पॉपुलरली नोन एज 9 शेड्यूल्स केस. सो इसमें क्या ऐड हुआ? रूल ऑफ लॉ, IR कोएल्हो केस, वेरी वेरी इंपॉर्टेंट. रूल ऑफ लॉ, सेपरेशन ऑफ पावर, प्रिंसिपल और एसेंस अंडरलाइंग फंडामेंटल राइट्स, जुडिशियल रिव्यू, प्रिंसिपल ऑफ इक्वलिटी. ओके, रूल ऑफ लॉ, सेपरेशन ऑफ पावर, प्रिंसिपल्स और एसेंस ऑफ अंडरलाइंग फंडामेंटल राइट्स, जुडिशियल रिव्यू, प्रिंसिपल ऑफ इक्वलिटी. देन राम जेठमलानी case 2011, powers of Supreme Court under Article 32, powers of Supreme Court under Article 32, that is constitutional remedy. Then Namit Sharma case, freedom and dignity of individual, freedom and dignity of individual. Okay. Then Madras Bar Association, last case Madras Bar Association added the judicial review and power of the high courts under Article 226, 227. Okay, clear? So thank you for watching. Stay tuned for next class.